Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I call up H.R. 661, Sarah's Law, for purposes of markup. I move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 661.
Without objection, the bill be considered as read and open for amendment at any point. The chair now recognizes the gentleman from California, Mr. McClintock, for an opening statement.
Thank you, Mr. Chairman. Biden's America has become a nation without borders as it has deliberately released millions of illegal aliens into the country. Among the many terrible consequences are the growing number of assaults on the men and women sworn to protect and serve our communities, far-left prosecutors releasing those same criminals back onto our streets, sanctuary city policies shielding criminal aliens from accountability, illegal aliens robbing hardworking Americans, the tragic murder of a 22-year-old Georgia nursing student, and now, again, we discuss another tragedy and a bill that bears another victim's name, Sarah's Law, named after 21-year-old Sarah Root. On January 31st, 2016, as Sarah drove home after a day of celebrating her college graduation, an illegal alien who was street racing while drunk slammed into Sarah's SUV, snapping Sarah's spine and fracturing her skull. Sarah died days later on February 4th. Within hours of her death, a judge set the illegal alien's bond at $50,000. The illegal alien posted bond and was released the next day. The alien who murdered Sarah then absconded and to this day remains at large. Even though the alien was charged with motor vehicle homicide, the Obama administration refused to lodge a detainer against Sarah Root's killer. In fact, despite a request by Omaha, Nebraska police to obtain an immigration detainer for the illegal alien, the agency declined. According to a news report, ICE said the agency declined the detainer, quote, because the illegal alien had not been convicted of a criminal charge and was, quote, not an enforcement priority. At a 2016 hearing before the House Committee on Oversight and Government Reform, then ICE Director Sarah Saldana further attempted to justify the decision not to detain the man. She said, quote, an individual from ICE looked at the specific facts and circumstances related to that matter. The individual had no criminal convictions, previous criminal convictions, and made a determination based on his judgment that he did not need to be detained, unquote. Well, 8 years after Sarah Root's death, the Biden administration has not learned from the Obama administration's failures. We saw these consequences just last month with 22-year-old Georgia nursing student Laken Riley, who was allegedly murdered by an illegal alien who the Biden administration paroled into this country in 2022 and who was previously arrested in New York City for endangering a child. Open borders Democrats never seem to learn, and the American people continue to pay the price. To my Democratic colleagues, I ask, how many more laws with names of victims attached to them do we need to pass before you will take this crisis seriously? How many American citizens must die at the hands of illegal aliens before we all agree that these tragedies are all preventable? Must the name of my child or your child be the one attached to the next HR number before Democrats can vote yes on these common sense bills? How much more blood must be shed before we can all join in calling for an absolute end to the Biden administration's reckless open borders policies that are threatening our safety, devastating our families, and destroying our country? Enough is enough. Sarah's Law closes a glaring loophole in immigration law by mandating that immigration detention for certain aliens, like Sarah Root's killer, who are arrested for, charged with, admit to, or are convicted of any crime that resulted in someone's death or serious bodily injury. In doing so, H.R. 661 seeks to prevent avoidable tragedies caused by illegal aliens and ensures that dangerous criminal aliens are more quickly removed from the United States. This bill doesn't address the entire immigration crisis in this country, but it's a key part of such reforms. I urge my colleagues to support Sarah's Law, honor its namesake, and take seriously the problem of criminal aliens victimizing our citizens. And I yield back the balance of my time.
Gentleman yields back. The chair now recognizes the ranking member for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, let's be clear. Those who commit violent crimes that result in the death or injury of individuals should be prosecuted to the fullest extent of the law. The bill before us today, however, will not solve the problem that the majority thinks it will, or claims to think it will. In fact, it might frustrate attempts by victims and prosecutors to seek justice. It also follows a familiar theme from the Republican majority, exploiting a tragic story with legislation that merely targets and scapegoats immigrants while doing nothing to address the situation at the border. The legislation before us today commemorates the tragic death of Sarah Root, who was killed by a drunk driver who entered the country unlawfully in 2013. Unfortunately, this individual never faced justice after a local judge released him on bond while the charges were pending. He became a fugitive, and ever since, Sarah Root's family has rightly sought justice for the death of their daughter. This case is a true tragedy, and I want to express my condolences to her family. But the legislation before us today would go way beyond addressing this issue. It would subject to mandatory detention any undocumented immigrants merely arrested or charged with committing an act that resulted in serious injury or death, along with those who are convicted or who admit to committing such acts. Like so many other bills we have considered in recent weeks, this legislation represents a gross overreach by subjecting someone who is merely arrested, who has never even been charged with a crime, to mandatory detention. As we have discussed previously, misidentification can subject someone to punishment for someone else's crime. Mr. Massey correctly noted in our markup last month that such punishments are imposed far more often on people of color. He praised Democrats for our consistency in supporting his bill regarding gun background checks, and I hope that we will find similar consistency on the Republican side today. There are far too many examples of wrongful arrests or charges due to mistaken identity or the use of flawed facial recognition technology. For example, Scottsdale, Arizona just had to settle a lawsuit for $200,000 in which a woman was wrongfully arrested for livelihood. We should not compound those issues by introducing mandatory detention into the equation as well. Moreover, I think my Republican colleagues have forgotten that the immigration detention system is by definition civil, and it should not be used in a punitive nature. A person should have their day in court first. Then, if appropriate, immigration consequences will follow. To be clear, under current immigration law, being convicted of or admitting to committing a crime involving moral turpitude, in which the crime is punishable by imprisonment of 1 year or more, already results in an individual being subject to mandatory detention. As a result, people who are convicted of or who admit to committing an act that results in serious injury or death are already subject to mandatory detention under our laws. This bill would not change that fact. But the breadth of this bill means that even innocent people will find themselves subjected to mandatory detention. Setting aside the due process concerns, this legislation would also have the perverse effect of depriving victims and their families of justice. Similarly, state and local prosecutors often express concerns that ICE will take custody before criminal proceedings are completed, which frustrates prosecutors, judges, and victims' families. If this legislation had been in place at the time of Ms. Root's death, ICE would have issued a detainer after her alleged killer was charged with a crime, and if resources allowed, it would have taken custody of him and then swiftly removed him from the country due to his previous infractions. He would never have been transferred back to local custody to face justice the way the Root family desires. This legislation is just one more example of the shoddy approach to legislating taken by this Republican majority, in which headlines are more important than results. Rather than taking a careful and thoughtful approach that would avoid unintended consequences, the majority legislates first and asks questions later. I urge my colleagues to rethink this wrong-headed legislation and to work in a bipartisan manner on meaningful solutions to our broken immigration system. Thank you, and I yield back.
Gentleman yields back without objection. All other opening statements will be included in the record. The chair recognizes the gentleman from California for the purposes of offering an amendment in the nature of a substitute. The clerk will report.
Amendment in the nature of a substitute to H.R. 661.
Without objection, the amendment will be considered as read, and the gentleman is recognized to, the gentleman from California is recognized to explain the amendment.
Thank you, Mr. Chairman. This amendment makes small technical changes throughout. It also requires the DHS Secretary to issue a detainer for the criminal aliens covered by the bill, and if the aliens are not otherwise detained, to take custody of them. This amendment also expands the categories of aliens to which mandatory detention applies to include aliens arrested for, admitting to, or convicted of a crime that resulted in death or serious bodily injury. With left-wing prosecutors who may never bring charges against someone, these changes are essential to ensure that there are no loopholes for criminal aliens or their far-left apologists to exploit. I'd urge my colleagues to support the amendment in the nature of a substitute to Sarah's law and yield back.
The gentleman yields back. Who seeks recognition? Mr. Van Drew, the gentleman from New Jersey is recognized.
Thank you, Chairman. I know we've spoken about this ad nauseum, but it's an important issue, and I guess I just can't let it go. You know, we sit on the other side that we're exploiting a tragic story and a tragic situation. We're not exploiting it. We're trying to stop these tragic situations from happening over and over again. It's now become a familiar story. Left-wing prosecutors, left-wing attorney generals, they let people out after they've committed crimes, and unfortunately, in numbers of cases now, they commit the ultimate crime, whether it's Sarah Root, Laken Riley, or Washington State Trooper Christopher Gadd. They've lost their lives. Condolences don't work. At the beginning of these debates, there's folks that say, I give my condolences, but we're not going to change anything. We're going to leave everything the same. We're not going to do anything. It doesn't work. It doesn't cut it. As we sit in our comfy chairs and we debate, people lose their lives brutally. And as lawmakers, there's simply no excuse for not enacting policies to stop harming Americans. But that's what this Biden border agenda does. When you allow millions of unvetted people to enter our country, when you don't know where they're going, who they are, what their intentions are, when you hamper law enforcement's ability to go after and deport lawbreakers, you are making Americans and America less safe, period. End of story. These people are here illegally. I don't know what we don't get about that. If anything, you have a right to detain them for just breaking the law and being here illegally. It shouldn't take a crime. But Biden and Mayorkas, they've bent over backwards to allow as many of these people into our country as they possibly can, and innocent Americans have lost their lives. This bill is just one more very good common sense measure to ensure that we are protecting our constituents, our Americans, and that we are detaining and removing the worst of the worst that are here illegally. We moved similar legislation, my bill, through this committee that would detain and deport illegals that assault law enforcement. I am with Member McClintock. He is doing the right thing. This bill is the right thing. We cannot overlook this. We can't pretend it's not there. We can't put a blindfold on. These people need to be detained and they need to be deported. This is a time for choosing for all of us who are going to vote. You're either with the Americans that live here, work here, break their back here, and many of whom are legal immigrants who are here, or you're with illegal immigrants, some of whom are breaking the law, some of whom are committing the ultimate act of violence. I don't know. It's an easy choice for me. I hope it's an easy choice for my colleagues. I yield back.
If the gentleman will yield for just a moment.
I yield.
I just wanted to thank the gentleman for his comments, but also to give full credit to the bill's author, Randy Feenstra. I'm simply carrying it here in the committee. He deserves full credit for introducing this bill and seeing it through to hopefully a successful conclusion.
I will reclaim my time and say, on a lighter note, you are one of the kinder, gentler, nicer people that would actually do that. And I yield back to the chairman.
The gentleman yields back, and I agree with his sentiments about the gentleman from California. And the gentleman from Washington's a kind person as well, and she is now recognized.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report. Gentleman from Florida reserves point of order.
Amendment to the
Without
amendment.
objection, the amendment will be considered as read. The gentlelady from Washington is recognized to explain her amendment.
Thank you, Mr. Chairman. What happened to Sarah Root is a tragedy, and as a mother, my heart aches for her family. No parent should ever have to go through the unbearable pain of having to bury their child. Sadly, passing this legislation would not bring Sarah's killer to justice. Sarah's family was failed by the government on multiple levels, and in fact, I know that they've been going after the local judge in this particular case. Fundamentally, this is a problem best solved at the local level, where they are better equipped to avoid unintended consequences. Unfortunately, the legislation before us today is an imprecise federal bill that would make a massive change to the national immigration system. This sort of bill acts a bit like a sledgehammer, hammering away at the problem, but causing an enormous amount of damage in its wake. Through this bill's extraordinary breadth, it will put large numbers of people, including DACA recipients and TPS holders, at risk of being subject to mandatory detention, even if they are innocent of the crimes of which they are accused. Like all of the immigration enforcement bills we have marked up so far in this Congress, this bill does absolutely nothing to fix the immigration system, and it has zero chance of becoming law. On the day before the government is set to shut down, this is not how we should be spending our time. We should perhaps be discussing the recent Congressional Budget Office's assessment that over the next 10 years, immigration is going to grow the economy by $7 trillion and increase revenue by $1 trillion. We could discuss how a new government study shows that refugees and asylees have a net positive impact of $124 billion over 10 years. But no, instead, we're taking up legislation that has no chance of becoming law, does nothing to fix the system, and demonizes immigrants and immigration. The amendment I'm offering today would address some of the very broad consequences of this bill. Under the current version, someone can be subject to mandatory immigration detention simply for being arrested or charged with a crime that led to serious bodily injury or death. But as we have discussed in the previous bills that we've discussed in this committee, people are mistakenly arrested and charged with crimes far too often in this country. Do we really think that it makes sense to subject them to mandatory detention, even if they were wrongly arrested and then exonerated? A mistaken arrest can be a huge burden on an innocent person. Just look at what happened last year in Kenosha, Wisconsin. An African-American couple was eating dinner at an Applebee's with their 1-year-old son when the police came in looking for a couple who had just committed a hit and run. While the actual perpetrators hid in the restroom, the police violently arrested the innocent couple even while the father was holding the child in his arms. It took half a year in court to get the charges against this couple dropped, but the psychological and emotional scars from that, I'm sure, still remain. If this couple had been DACA or TPS recipients, and this bill was the law of the land, they might be in immigration detention now, even 2 months after they were exonerated. My amendment would also require that there be a conviction before the mandatory notification requirement under this bill takes effect. Releasing this type of personal information to a victim's family based on a mere charge is extremely dangerous, and it is not something we should be doing. Last month, we unanimously moved Mr. Massey's bill, H.R. 6824, out of committee. That bill is aimed at identifying and preventing the negative consequences of racially biased misidentifications in the gun background check system. I don't understand why we would want to move forward with a bill today that would amplify those same negative consequences in the immigration system. We passed Mr. Massey's bill in a bipartisan manner, and I hope that my colleagues are willing to work with us on this legislation as well. Unfortunately, without my amendment, the bill before us today has significant unintended consequences, and I would not be able to support it. I urge my colleagues to accept my amendment, and I yield back the balance of my time.
The gentlelady yields back. Is there further discussion on the amendment? I will, gentleman withdraws his point of order. I'll recognize myself for 5 minutes. I would just remind my friend that Laken Riley's accused killer was never convicted of a prior crime. He was arrested and released by New York authorities. Arrested and released. Arrested and released. That's the Democrats' favorite pastime in our cities that they control, and it's a principal cause of the carnage which those cities are now suffering, and whose constituents are now starting to awaken to the damage of these foolish policies. We've been through this discussion many times before on similar bills, but since the gentlelady wishes to make her points again, I'll make my points again as well. I wish for a change that the Democrats would be just as concerned with the rights of Americans as they are with the rights of illegal aliens and the crimes that they're committing in our communities. But let's just call this out real quick. Under current law, an alien already can be subject to mandatory detention without a conviction. We've gone through these examples many times, but somehow they just don't sink in. An illegal alien who admits to committing a crime involving moral turpitude, or who admits to committing a controlled substance offense. Any alien, including a green card holder who commits a drug offense. All of these are subject to mandatory detention under current law. In 2019, the Supreme Court noted the expansive nature of mandatory detention. They highlighted that part of the reason for mandatory detention is to reach aliens who necessarily escape conviction, and another part sweeps in aliens for whom there is no reason to expect police, as opposed to immigration officials, will have reason to arrest. That's why we have these provisions in law. Under current law, even the spouses and children of certain illegal aliens must be detained if the DHS secretary knows or has reason to believe that a spouse or parent trafficked drugs and the family members knowingly received a benefit, financial or otherwise, from that activity. So if it's the breadth of this policy that the Democrats are concerned about, it certainly sounds like they'd like to strike down the entire mandatory
would the gentleman
detention
yield?
section. No, not till I'm done. So again, your objection is the entire mandatory detention section, which already has been the law of the land.
That's why I was asking if you'd
applied
yield.
to aliens for decades. Sarah's law makes so much sense that I think Americans would be surprised to know that it's not already the law of the land. This amendment would strike this provision, and let me.
Would the gentleman yield? I just want to clarify something,
Let
Mr.
me
Chairman.
raise one other set of points first. We keep hearing that these are illegal aliens who will be wrongly detained. But here's the reality. Aliens who are inadmissible for being in the U.S. illegally or lacking valid documents should have been detained once they crossed the border in the first place. And they should have been continued in detention throughout their immigration proceedings. That is the current law. And aliens who've had their visas revoked or failed to comply with their non-immigrant status no longer have a basis to remain in the United States. To even lodge a detainer against an alien or to arrest an alien in the first place, DHS has to have probable cause that the alien is removable from the United States. Once detained, if an alien claims he's wrongly subject to mandatory detention, he can request review before an immigration judge, who will then determine whether the alien is in fact an alien, whether he fits within the category of mandatory detention, and whether DHS is substantially unlikely to establish that the alien is subject to mandatory detention. All those rights are in existing law, and all of those rights apply in this case. And that detention is far from indefinite. According to data from the Executive Office for Immigration Review, the median case completion time for an alien in detention was only 42 days in fiscal year 2033. Yet if the alien is truly innocent and wrongly detained, as the Democrats argue, then the alien can quickly receive asylum and be released. If the Democrats cared about public safety and the constituents they serve, I think they would reject the amendment and they would support this bill. But that doesn't seem to be the case, and I'll be happy to yield to the gentlelady for my remaining time.
I may need a little bit more time, but I just wanted to be very clear about something. I am granting that if somebody is convicted of or admits having committed or admits committing acts which constitute the essential elements, of any offense that resulted in the death or serious bodily injury. I'm not touching that, Mr. Chairman. My amendment does not do anything with that.
Reclaiming my time. You should at
Well, I
least
think your
understand
time
that
is
that
over, so
person,
I'm gonna-
that person.
I think your time is expired.
That person is subject to detention anyway because they've committed the crime of illegally crossing the
you're-
border.
I think
Further discussion
Process point here, Mr. Chairman. I think your time is over.
by 10 seconds. It was by 10 seconds.
I know, but
You
I-
interrupted me, but I'll be happy to recognize Ms. Scanlon now.
Thank you, and I yield to the gentlewoman from Washington.
Thank you. Again, I just wanted to make it clear that it is the case right now that if you're convicted of, or admit to having convicted, or admit committing acts which constitute the essential elements of any offense that resulted in the death or serious bodily injury, you are subject to mandatory detention. What this bill does, though, it expands that dramatically. And it says if you are charged with or arrested for, and that is the problem that I have. That is why I am submitting my amendment, because I am saying just being charged with or being arrested for a crime does not mean that you should suddenly give up all your due process rights and be mandatorily detained. So I am saying, yes, I understand what the law says right now, but this bill is a dramatic over-expansion, and it fundamentally hurts due process rights. And frankly, it's extremely dangerous, because if somebody is just charged with a crime or is just arrested for a crime, you're essentially saying that from that point on, they have to be mandatorily detained. Not only has no administration ever been able to mandatorily detain everybody that is subject to mandatory detention right now, that's true of Republicans and Democratic administrations. But now what you're saying is we're going to expand that population even more, and we're going to mandatorily detain or require to mandatorily detain people who are just charged with a crime. And the reason I brought up Mr. Massey's bill from last time is because we know that people are charged unjustly all the time. We know that that happens, and we need to be really sure that we're protecting due process for everybody. And I care about due process for everybody regardless of legal status. I care about due process for the people that are here in this country, making sure that we have the ability for people to go through that process. And so all my amendment does is say, let's make sure we at least have due process for people who are charged with or arrested for, but not yet haven't gone through the process, don't have a conviction, haven't admitted to having convicted. I don't touch any of that that's in your bill, Mr. Chairman. I literally just have an amendment saying if you're charged with or arrested with, you should not be mandatorily detained because you haven't gone through the legal due process that you are due for. So that is what my amendment is, and I reject the assertion that somehow Democrats want to not adhere even to what is current law or want to allow everybody. No, we just want people to have due process, and what your bill does is expand dramatically and hurt the due process rights, including, by the way, of legal residents who are here, people who are on TPS, people who are DACA recipients, people who have the legal ability to be here. This is a real problem, and I think everybody, including on the other side, if you believe in due process, you should want to support this amendment. I yield back to the gentlelady from Pennsylvania.
Thank you, and I yield back.
Gentlelady yields back. Is there further discussion? Mr. Biggs.
Thank you, Mr. Chairman. I would have to oppose this proposed amendment, and I'll tell you why. I'm just going to give 3 quick reasons. Number 1, under Title VIII, someone who is not inspected and admitted into the United States is already subject to mandatory detention. Failure to detain those individuals is not consistent with the law. It may be consistent with practice, but it's not consistent with the law. The reality is, when an individual is released instead of held mandatorily, we have found that we lose complete track of them. We don't know where they are. So it makes almost a charge like this becomes almost a nullity. The third thing is due process. In most cases, if you are charged with committing a murder or an aggravated assault, you will be brought before a court to determine your release status. Failure to have adequate ties to a community would be one reason why you'd be remained. Flight risk would be another reason you'd be remanded and held. And I think that this bill, as it is consistent with current due process and the reality of the situation, and also Title VIII, and so I oppose the amendment. Yield back.
Could the gentleman yield for just a moment?
So I'll yield to you, Mr. Chairman.
I just want to again emphasize the point that you made. An illegal alien is already subject to mandatory detention under existing law. That law was ignored in the case of Sarah Root's killer. It's being ignored in the case of more than 6 million illegal aliens that this administration has deliberately released into this country, and about whom we know very, very little. And the fine point of the matter comes down to this. If this law had been enforced, or if this bill had become law, Sarah Root would be alive today. And that's the bottom line. And I thank the gentleman for yielding, and the gentleman yields back, and the chair recognizes Mr. Nadler for 5 minutes.
I thank the chairman. Mr. Chairman, this bill makes subject to mandatory detention anybody arrested or charged with, never mind convicted, of various crimes. That is opposed to the basic concept of due process. Now, some of the Republicans say, well, illegal aliens are already subject to mandatory detention, or ought to be. But we're not only talking about, but this bill is talking not only about illegal aliens. People who are here legally under DACA, for example. People who were brought here at 2 years old 30 years ago and are clearly Americans except in legal status. Or TPS recipients. These people are here legally and yet would be subject to mandatory detention if arrested or charged with, never mind being convicted of or admitting to. That violates basic notions of due process. In addition to which, there's total hypocrisy. This bill will subject a lot more people to mandatory detention at a time when Republicans refuse to give the Department of Homeland Security the resources it needs to enforce the existing law. Congress has never appropriated, and no administration has ever requested sufficient resources to detain all non-citizens who fall under the mandatory detention categories. President Trump never tried to detain all migrants subject to mandatory detention. And this bill would expand who is subject to mandatory detention to people here legally who may never have committed the crime, who are simply arrested or charged with, and put them into facilities that we can't even fit all the people who should be in these facilities because Congress hasn't appropriated the money. The Trump administration hasn't requested sufficient money. The Biden administration requested, I think it was $16 billion to increase this and didn't get it. So this bill would simply do violence to all our notions of due process and do nothing to help solve the problem at the border. We have a problem at the border, but it wasn't deliberately created by President Biden. It existed under President Trump. It exists under President Biden. Conditions abroad have increased the number of people who seek to come here, conditions for which the United States has no responsibility. Climate change, political violence, gang violence, instability. These are what drive people to try to leave their homes. Nobody wants to leave their home where they've grown up unless circumstances make it necessary for them to do so, usually. So this bill does violence to due process, subjects people who have not been convicted of any malfeasance of any sort to mandatory detention, and that does not increase anybody's safety. I yield back.
Gentleman yields back. Is there further discussion? Seeing none, the question occurs on the amendment offered by the gentlelady from Washington. Those in favor say aye.
Aye.
Those opposed say no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed to.
Roll call, please.
Recorded votes requested. The clerk will call the roll.
Mr. Jordan, Mr. Isa, Mr. Buck, Mr. Gates votes no. Mr. Biggs, Mr. Biggs votes no. Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Bishop?